All right.
Thank you for standing, folks. Please be seated. All right, good afternoon, everyone. This is CR 2015-00862, State of Arizona versus Stephen Jones. Mr. Jones is present with counsel, Mr. McCowan, Mr. Davidson. Good afternoon to all of you. The state is represented by Mr. Hammond Barker, Mr. Brian Shea. Good afternoon to both of you as well. There's several motions, two motions that we're here to decide and to hear. Have argued. The defense has filed a motion to remand to the grand jury for a new determination of probable cause, and also a motion to review conditions of release. I should also indicate that I believe we have some victims here, and we have victim representatives here as well. Is that correct?
That is correct, Your Honor.
Okay. I'm going to take the motion to remand first. So, Mr. Davidson, it's your motion.
Thank you, Your Honor.
Go ahead.
Thank you. Your Honor, the defense raised several issues in the... Your Honor, we can address the court from here.
Whatever's most comfortable for you is fine. Just as long as you can keep your voice up so that Steve can take down the argument.
Certainly, Your Honor. Your Honor, the defense raised several motions in its motion to remand. The state filed a rather expansive response, including a lot of facts that not only are in dispute but aren't really germane or even relevant to the discussion and the issue of whether this case should be remanded back to the grand jury. As the court's well aware, the grand jury is there to act as a check. It's there to act as a balance against the prosecutor's power. It provides the accused the ability to make sure that there's a probable cause before felony cases can be filed. I wasn't there, Mr. McCowan wasn't there, obviously Mr. Jones wasn't there. It was incumbent upon the prosecutor to present clearly exculpatory evidence. It was incumbent upon the prosecutor to present evidence in a fair and impartial manner. And they failed to do that. And irrespective of how many pages of relevant facts they include in their response, talking about double taps and tactical flashlights and .40 caliber blocks, they spend actually very little time addressing the issues that are problematic for them with regard to the way that they presented this case to the grand jury. And I think that's pretty apparent. In terms of the actual issues themselves, Your Honor, I think the two or three that are most troubling and to defense and should be troubling to the court is the manner in which Nicholas Peering's hospital statement was presented to the police. Let's be very clear about this. Nicholas Peering, who is one of the alleged victims as to the aggravated assault charges, was shot during this incident last October. He was transported to the hospital. It was in the emergency room. He was contacted by Detective, I believe Jacob Ellis is his name. Detective Jacob Ellis conducted 2 interviews with Mr. Peering. They were both recorded. The state has those recordings. They disclosed them to the defense. In those recordings and in those interviews, both times that he talks to Mr. Peering makes it very clear. He basically says that he went across the street from the courtyard and that he came up behind a group of people where Colin Breaux, the decedent, was. And essentially, just as Stephen approached with the flashlight, which we now all know was attached to his gun, and said words to the effect of step back or get back, that from an elevated position, essentially either right behind or shoulder to shoulder with Colin Breaux, that Mr. Peering jumps forward. That's important. And the state knows that's important because this is a self-defense case. This is a case where they've taken the somewhat astonishing position that Mr. Jones acted with self-defense, or acted with premeditation. Excuse me. Now, Mr. Jones made it abundantly clear when he was interviewed by the police, well before they went to the grand jury, Your Honor, that he believed that these 2 people were advancing on him. Those 2 people being Mr. Breaux and Mr. Peering. Mr. Peering himself, Your Honor, admitted as much to the police at the hospital hours after the shooting, that was basically what he was doing. It may not have been his intent, according to his statement to the police, to jump at Stephen or to attack him or to do him harm, but we have to look at this through the lens of how it was perceived by Mr. Jones. And when Mr. Jones tells the police that these two gentlemen, these two individuals were advancing at me, and the state, incidentally, is going to take issue with that, it would seem like a rather important fact that one of those two individuals himself essentially admitted that he was jumping towards Mr. Jones. But they didn't present that. And it's worse than that. If it ended there, it would be bad enough, but it's worse than that, because when they present the case to the grand jury, what they presented was this second interview that Mr. Peering gave. Curiously, a week and a half later, with two detectives and two prosecutors in the room. And now all of a sudden, Mr. Peering is, well, I was actually 10 to 12 feet away when I saw Colin get shot, and then I approached where Mr. Jones and where Colin were. That's the only statement from Mr. Peering that they presented to the grand jury. And the worst thing about it, Judge, is that they not only completely ignored the statement that Mr. Peering gave at the hospital, but when they presented the subsequent statement that Mr. Peering gave to Mr. Shea and Mr. Barker, they characterized it as being the statement that he gave at the hospital just hours after the shooting. There's no dispute that that wasn't what he said at the hospital. And they characterized it as such. That, Your Honor, is a misstatement, and it's not a trivial one. It's a misstatement that operated to prejudice my client and to deprive them the right to have a grand jury make an informed decision about this case. Now, the state takes the position in its response. The state takes the position in its response that, well, Mr. Peering's initial statement at the hospital was ambiguous, and geez, he was being treated for injuries, and gosh, how did we even know that he knew what he was talking about? That's why I went and talked to him later. Well, his statement was actually pretty clear. I mean, the detective not only didn't have any problems writing in a report what Mr. Peering said at the hospital, but he actually recorded it. And I want to play for the court. I don't know if it's marked, if I could inquire of your clerk what exhibit the disc is. 2. Exhibit 2, Your Honor, is a CD or a DVD with 2 audio recordings. One of them is the interview with Nick Peering at the hospital that the state characterizes as being taken out of context in Mr. Jones's motion and being less comprehensive than the subsequent statement that they obtained.
Without objection? No objection. 2 is admitted.
Thank you.
All I know is altercation. They were going across the street. I went over there and see what was going on. He was talking. I'm listening. He was talking to one kid. If he was talking to one kid, another kid, back there where he comes. The kid comes from the parking lot.
Okay, stop.
I gotta hear it. Listen to it. I mean, I can't. That microphone is not working, so I gotta hear it.
Sure.
Go ahead, play it again.
All I know is altercation apparently. They were going across the street. I went over there to see what was going on. He was talking. I'm listening. He was talking to one kid. And he was talking to one kid, another kid, and back there where he comes. The kid comes from the parking lot. He comes to the parking lot, shines a flashlight, back up. But naturally, everyone else saw like wrestling and like making music. I take it out, the flashlight, and I got shots. Colin, my roommate, he to the left of me, he's south. I take it out, he drops the floor. And I didn't even take a step in, I jumped over a bush, and I get hit once, and this one doesn't one, I think I hit my arm first, his face, and I didn't even know what was going on.
And Your Honor, actually there's one other. There was a pause where medical staff was attending to Mr. Peering. The interview recommenced.
I don't know. So I ran up, I knew there was no location. I was trying to calm people down. I jumped over Brad Mountain into a roadway, right? And it's a 2-foot gap in the roadway and the parking lot. So I was trying to calm people down. And I went over there and I said, hey, come down, come down. Step back, and at the exact moment he said step back, I jumped from the top to the lower part, and I got shot in the theater. So it was more towards that side, or it was more on the street in front of me. I was running up behind people, trying to calm it down. He made me try to calm my roommate down. Yeah. And there's about 4 people on the opposite side of us, and then 3 of which were like, okay, okay, we're like, leave. I don't even know if it's more than he pulled me in the parking lot and just should have shot the flashlight, like step back as I was jumping. Colin was like kind of heading towards me, and kind of like towards someone else. And he put the flashlight up, and as soon as he did, he started shooting. That was
Thank you. The audio speaks for itself. Mr. Peering said that he ran up. There was a 2-foot gap between the elevated position where he was and the edge of the parking lot where Mr. Bro was. And at that exact moment, when Stephen said, step back or get back, he jumped. He said that twice. Where's the ambiguity? There is none. It was all too ambiguous. That's the unambiguous, and that's why they didn't present it. And again, this is no trivial, unimportant fact. This is central to the issue of whether Stephen acted with premeditation and whether he acted with reasonable self-defense. Similarly, Your Honor, we have a situation where Kyle Zintek's statement was not properly conveyed to the jury. Although perhaps not as blatant as the omission from Mr. Peering, Mr. Zintek says that Colin, the decedent, stepped up to Stephen right before shots were fired. The state tries to accuse that and say, well, when pressed on it, he said it was 4 feet away, as if someone stepping up from 4 feet away is somehow less intimidating than someone stepping up a distance of 3 feet away. Whether it's 3 feet or 4 feet or 2 feet or 6 feet, when looked against the backdrop of all the underlying circumstances and the assault that he had just suffered, the fact that you have one of the victims, a friend of the decedent, telling the police that the decedent, who was shot by my client, who claimed self-defense, had stepped up to him the very moment before he was shot, could not be more exculpatory. And to characterize it as anything other than clearly exculpatory simply doesn't hold water. I simply can't envision a scenario where we could have a situation where someone is shot and the person who fires the gun says, he was attacking me, I was in fear for my life, and the state sits on a statement from another witness who was present that the alleged victim stepped up to the defendant or the shooter just seconds before the shooting happened. I think these two omissions by themselves, Your Honor, certainly collectively require that this case be sent back to another grand jury to be reconsidered and be reevaluated whether probable cause exists. There's also some dispute, Your Honor, about whether the state should have presented evidence about Shea McConnell's statement that Mr. Bro had punched Stephen right before the incident occurred. I don't think there's any dispute that Stephen was punched. He had a bloody lip. His glasses got knocked off his face. He had a lot of injuries that were noted by the detectives who investigated the case. Okay? So it's not a question of whether he was hit. It's a question of who hit him. Shea McConnell says that he thought it was Colin Bro, identifies him as wearing the same white shirt that Mr. Bro was seen wearing as the one who punched Stephen. Now, the state goes out of its way to point out that no one else says that Mr. Bro was the one who punched Stephen. What they don't point out, though, is that no one says that it wasn't Mr. Bro. So the only real statement we have identifying the person who punched Stephen was from Shea McConnell. And Shea McConnell said it was Colin Bro. Well, that fact isn't particularly expedient to the state's case, and that likewise was left out. The fact that Colin being identified as the one who punched Stephen was couched in terms of, I thought it was him, or that Mr. McConnell used the word thought or believed when he described to the detectives that it was Colin who threw the punch, doesn't give the prosecutor license to omit that information from the grand jury. If they want to cross-examine Shea at trial and say, well, you said you thought, you didn't say you were certain, that's fine, but we're not at trial. This isn't supposed to be a mini-trial. This is supposed to be a fair, impartial, and complete presentation of the evidence for the grand jury to consider. If they were so hung up on the fact that Colin Breaux was identified by Shea, and Shea used the word thought or believed when he identified Colin, they could have conveyed that to the grand jury judge. They could have said that Mr. McConnell said that he thought Mr. Breaux was the one who punched Stephen. They didn't even do that. They withheld it from the grand jury. And again, the grand jury made a decision, a non-unanimous one, I note, to indict Stephen without knowing that one of Stephen's friends identified the decedent as the person who punched Stephen just moments earlier. One of the other issues that the state takes issue with and suggests that because Mr. Jones is cited as a source of that information is the fact that Colin Breaux was leaning or lunging towards him when the shots were fired. I don't think the court requires me to elaborate in any great measure of detail as to why that is perhaps one of the most important issues of this case. When the post-mortem was conducted, the track path, or the wound path, for the two wounds, gunshot wounds that the decedent suffered, had a downward path. It's interesting because in my motion, Your Honor, I addressed two things related to that as it pertains to the grand jury presentation. One is that when it was presented to the grand jury, that being the description of the wounds, it was done in a very muddied and inartful way. The state elicited testimony that the projectile was shot at kind of a down angle. Well, what in the world does kind of a down angle mean? Does that mean that the wound path is going down from here? That we're starting from the resting location of the bullet forward anteriorly? Or does it mean that it was coming down from above, as was the case? It certainly isn't clear from the way that it was described to the grand jury. And without benefit of the medical examiner's report that Mr. McCowan and I had, how in the world would the grand jury have known that? I think the state tacitly conceded that point because in their response that was so long they had to file a request to include more pages than the rules would otherwise permit. They don't even address the issue that we raised in our motion, that it was muddied and unclear as to what exactly the wound path looked like. So putting that aside for the moment and the ambiguity as to how that was portrayed to the grand jury, we have the second issue of the importance of the wound path itself. This goes directly to the position of Mr. Breaux's body at the time the shots were fired. You have a round that went in, I believe, just above his left nipple and was removed from just above his lower back. You don't need to be a doctor or a medical examiner to reasonably infer from that Mr. Breaux was in a leaning and lunging position going forward when the shot was fired. And especially given the fact that they are going to try to impugn Mr. Jones' assertion that Colin was lunging at him when it happened, the jury should have known that there was indisputable physical evidence, medical evidence from the medical examiner, demonstrating that the injuries suffered by Mr. Breaux were entirely consistent with what Stephen said happened. They didn't do it. At best, they provided this muddy explanation, and without a clear picture of what the wounds looked like, the jury had no way of knowing that that was the case. Now, in its response, the state says, well, sorry, I have to look at it. I can't find it. Essentially, it sounds like the state intends to offer some type of magic bullet theory as to how this occurred, and that because Mr. McCowan and I are unable and unqualified to explain that away, that it would have been inappropriate for that evidence to be presented in its raw form to the grand jury. That's just nonsense. I mean, a layperson without a medical degree is perfectly capable of drawing reasonable inferences based on an accurate description of a wound path. Certainly if this were some other case where there was some dispute about whether somebody shot in self-defense or not, and you had an entry wound in the victim's back, I'm quite certain the state would have no problem making some unfavorable inferences against the accused based on that wound path. This is really no different. The grand jury should have heard that, and they didn't, Your Honor. Your Honor, the remainder of the issues I raised are essentially responded to by the state with their fallback position, which is that, well, maybe we didn't present this, maybe we did, but in any event, it's irrelevant because there was no self-defense here, and it's such a clear-cut case. I mean, that's basically what they say. They basically say even if the grand jury had known about it, it wouldn't have made a difference. And they repeatedly cite the fact that Stephen supposedly walked 90 feet from his car to where the shooting took place. I mean, that's basically the centerpiece of their position that everything we're talking about here today is somehow a moot point because it's so patently obvious that this was premeditated murder based on those alleged 90 feet that he walked. It's interesting, though, that when they presented the case to the grand jury, not a shred of evidence was presented as to the distance between Stephen's car and where the shooting occurred. It wasn't important enough for them to present to the grand jury, but now that they're being challenged based on the way they presented the facts to the grand jury and the theory of the case that they foisted on them, now we're hearing about these 90 feet. And now, based on evidence that wasn't even presented to the grand jury, the state's taking the position of, hey, look, Judge, it's so obvious that this kid is guilty. Why are we even arguing about whether he was crying and trying to arrange for medical attention for these young men right after the shooting was occurred? Or why does it matter that these people were drunk and had blood alcohol concentrations that were well beyond the legal limit where somebody could legally drive a car? Similarly, the state tries to muddy the waters as to the defendant's argument with regard to his injuries. No, we don't know which injuries that Stephen had were caused when he was punched, most likely by Colin Bro. And no, we don't know which injuries were specifically caused when he was pummeled thereafter as this large group convened on him and tried to take the gun from him when the second round of shots went off. But we don't have to know because his defense of justification, his self-defense, his reasonableness in discharging the second group of shots wherein Mr. Peering and Mr. Zintek, where Mr. Prado and Mr. Zintek were injured, were the direct result of the fact that he was being pummeled and that he had concerns for his safety. These people were trying to grab his gun. Certainly the injuries that he sustained during that melee goes directly to the reasonableness of his conduct, the reasonableness of his concern, and the reasonableness of his fear that he was going to get seriously hurt or killed unless he continued firing his weapon to get all these people off of him. But they didn't bother to present any of those injuries, Your Honor. At best, they said, well, he had a split lip and he lost his balance. Well, the report from the police quite clearly says that there were more injuries. Observed on Stephen's person. Injuries to his head, his back, his chest, his arm, his knees, and his wrist. But when asked what were the results of Stephen being punched in his face, the state's witness testified, his glasses get knocked off and he loses his balance. And then they compound it. They compound it by having the nerve in a response to say that Mr. Jones went back and fired because his pride was hurt. He was wounded. It wasn't his pride that was hurt. It was his entire body that was hurt. He had injuries just about on every portion of his body. And all the grand jury heard was that his glasses were knocked off and his lip was cut. They downplayed what he had gone through. They downplayed the injuries that were inflicted on him, again, because it plays into downplaying the self-defense concerns that he had and the reasonableness of the actions that he took to protect himself. We talked briefly in chambers, Your Honor, about the remaining issue. Let me back up. There's also the issue pertaining to Chase Irwin's statement. I don't want to take up everyone's time continuing to split hairs here, but I would respectfully submit that that's exactly what the state is doing with regard to this issue. Chase Irwin makes it very clear in his statement that he observed Colin Bro running across the street, and he thinks he was going to help Nick Peering, presumably, who got into a tiff with that guy. And the state says, well, that is a gross, that's their word, gross mischaracterization of what of what Chase Irwin said. Well, that's exactly what Chase Irwin said. And no, maybe Chase Irwin did not see Mr. Bro, after crossing the street, go into the parking lot where the confrontation occurred, but we didn't say that he saw Mr. Bro go into the parking lot where the confrontation occurred. That being said, it's not an unreasonable inference. In fact, any contrary inference would be unreasonable, that when Colin Bro's friend sees him running across the street directly towards the parking lot where all these other individuals are, according to Mr. Puring, continuing to advance on this group of kids to make them go away, that's exactly where he was heading. The state didn't present that, and the reason they didn't present that is because had the grand jury known that Mr. Bro was essentially running, maybe not, we couldn't show directly at Mr. Jones at that time, he at a minimum was running directly towards his location where this whole episode played out just moments later. They didn't hear that, they should have. Is Mr. Bro's running subject to maybe varying interpretations? Sure, and maybe they can try to advance those arguments at trial. But the obvious interpretation of that, Your Honor, the most obvious inference that the grand jury would have drawn is that Mr. Bro was running across the street because that's where Stephen and his friends were, and he was the aggressor in this situation. The grand jury didn't know that. It would have been impossible for them to have made an informed decision about the indictment in this case without knowing that information as well. I don't know when exactly the police found out about the high PACs of the alleged victims in this case. What I do know, Your Honor, is that Detective Jacob Ellis was at the hospital at Flagstaff Medical Center from approximately 1:30 in the morning to at least 5:30 in the morning. He was the detective who took the statement from Mr. Puring that we listened to a moment ago. It's obvious that he was there continuously. It's obvious that he was interacting with the medical staff. It was obvious that he at least noted with respect to Mr. Puring that he had some slurred speech or some other symptomatology that was consistent with alcohol consumption. When and how he found out specifically about the toxicology report from the hospital, which incidentally, according to the hospital records, those labs were done while these young men were still in the emergency room. So the county attorney's office may not have had the printed records until some days or weeks thereafter, but the tests themselves were done while these two young men were still in the hospital. I don't know, given the significance of the other problems with the prosecution's presentation of this case to the grand jury, frankly how important it is to Your Honor that they likewise left out the fact that these young men were, one of them at least was over a .200, but to the extent that that is a relevant issue, if Your Honor denies the motion to remand today, but believes that if that offer of proof would be developed factually with an evidentiary hearing, we would simply ask leave to adjourn these proceedings and to recommence with the defense, to conduct some discovery with Detective Jacob Ellis and make a determination as to when exactly they found that out. Because if they knew about it, that certainly should have been provided as well. Thank you.
Thank you, Mr. Davis. Mr. Barker.
Thank you, Your Honor. Well, Your Honor, we've heard a lot about things that the defense does not like about the presentation, but we haven't really heard why they are clearly exculpatory. And that's really the standard. We didn't hear much about the law. We heard a lot about some of the facts that they dispute. The defense's argument fails on every single point, and I'll go through those in order. As the court is aware, the standard is whether the state denied the defendant a substantial procedural right. That's the rule. And there's a couple ways that that could happen. And the two ways that the defense raises is that we failed to present clearly exculpatory evidence, or that we provided inaccurate or incomplete information that was material to the indictment. None of those occurred here. As the court is aware also, the court retains broad discretion in these matters. There's no mechanical test. There's no factors really to consider It's just the language of the rule in the common law that we have, the case law that we can glean some of these rules from. Let me talk about clearly exculpatory evidence first. That is defined as evidence that would deter a grand jury from finding the existence of probable cause. That's the definition the case law gives us. And by way of illustration, let me talk about the Morrow case. It was a Coconino County case, actually. The defendant cites it in his motion. We cited it as well. This is the case where the defendant had killed his own child. He indicated that he did it because the child was the devil. There was indication that he had some mental lapse, that there was mental health issues that he had in his background. And in fact, it was clear that he had been to multiple hospitals for mental health issues. None of that was presented to the grand jury by the state in that case, and no insanity language was read to the grand jury. The appellate court found, however, that while it tended to be exculpatory, it was not clearly exculpatory. It didn't meet that standard that we just talked about, that it would tend to deter a grand jury from finding probable cause. So that is the standard. It's a fairly high standard. The defense has not met that in any of these points. So let's talk about the things that the defense claims are clearly exculpatory. Kyle's statements, Kyle Zentek, one of the victims, you'll recall that the victim, Kyle, was shot twice in the back. He lost a kidney because of his injuries. He stated in a statement that he made to Sergeant O'Hagan, myself, Mr. Shea, in his hospital bed while he was recovering from these injuries, that Colin Breaux, he said, had gotten into, I think the words were, gotten into the defendant's face, or gotten into the guy's face. When we asked him what he meant by that, he said, well, it was about 4 feet away. That's what he meant by getting into his face. He was not nose to nose. And yes, there is a difference between being 10 feet away, 5 feet away, 1 foot away. Of course there is. But regardless, Judge, how Kyle Zentek, there's no dispute, by the way, that Kyle Zentek had no weapons, or I'm sorry, Colin Breaux had no weapons. There's no dispute even that his fists were down. He didn't have his hands up at the time he was shot twice by the defendant in the torso. Even if we took that statement out of context, as the defense does, that Colin Breaux was in the defendant's face, the defendant had no right to shoot him twice, to shoot him even once. So when we talk about clearly exculpatory evidence, we need to be very clear here. Is that the type of evidence that the grand jury would be thinking, oh man, okay, now that I know he was in his face, I guess it's okay for you to shoot an unarmed person? Of course not. That's not clearly exculpatory. The defense doesn't even talk about that standard. So there's one down. That does not change anything about the grand jury presentation. And again, the defense is cherry-picking statements that they would like presented, but don't look at the other statements about how Kyle indicated he was 4 feet away. Let's talk about Shea McConnell's statement that Colin was the one who punched the defendant. First, it wasn't clear. It's not clear in Shea McConnell's statement that it was Colin. He indicated that the person who had a white shirt on, he thought, also punched the defendant. Who was shot was also the person who punched the defendant. That's what Shea McConnell said. Nobody else in the area, and we're talking about a dozen people or so, say that they saw that Colin was the one who punched the defendant. But let's just suppose for a minute that that was true. Does that change anything about the case? Does it change the fact that the defendant went to his car, which by all accounts was about 100 feet away? By the way, no one was chasing him, even though he told the police that afterwards. He later said, well, when I looked around, no one was actually chasing me. He got to his car. At that point, he decided to unzip the case to his gun, pull out his .40 caliber Glock pistol, load a chamber, turn on the light on that handgun, and then walk some 90 feet to where this fray was happening. And when I say fray, there's no fighting occurring at this point. All that is occurring, and this is evidence that we knew at the time of the grand jury, evidence we know now. What was occurring at that point was a confrontation, an argument, verbal, maybe some chest puffing, nothing more. No weapons. Again, no weapons. The only person who had a weapon was the defendant, who walked at 90 feet and then confronted some people. And it's unclear exactly what he said. accounts vary. He said some words and then he began shooting unarmed people. Now, the defense, let me talk about that distance for a minute, because 90 feet is significant. I think 90 feet is probably twice the size of this courtroom, twice the distance or the width of this courtroom. We did present evidence of that to the grand jury. Maybe the defense forgets. We had a witness, Zach Volpo, who testified, or actually made a statement to the police, that he estimated the distance that the defendant traveled to be 30 to 35 yards. So yeah, we didn't have distance. That was presented to the grand jury, so they were aware of that. Getting back to Shay's statement, does it make it more justified that Colin Breaux, a minute or two before the defendant got his gun and fired upon him, punched the defendant in his face? Of course not. We know that the self-defense instruction indicates, the statute says, you're not justified to use deadly physical force unless you are threatened by someone who is by deadly physical force. You cannot bring a gun to a fist fight. That's what the law states. So if he was punched in the face, he doesn't get to get his gun out and walk 90 feet and then shoot people. So it's not clearly exculpatory evidence. It's not the type of evidence that would deter a grand jury from finding probable cause in this case. The state disagrees with that.
Is there a totality of the circumstances on that cause, that position, in terms of leading to the defendant believing that he was actually the reasonable person to believe that he was justified in using in physical force? So you have the confrontation, you have the punch, you then have, according to the defense, some sort of pursuit or something to the extent that he is injured or believes he's going to be injured. You're talking only about the punch. Was he punched? That's it. It kind of stops.
Right.
What about the totality of the circumstances leading up to the punch and just after the punch?
Of course. Yeah, and we presented all of that to the grand jury, Judge. I'm going to get to that in a minute, but let me just say, the state presented evidence to the grand jury that the defendant was punched in the face, that his glasses were knocked off, that he said that he feared for his life, that these guys were saying they're going to kill him. We presented all this to the grand jury. You had the grand jury transcript. You might remember we presented that. We presented the fact that he thought people were chasing him to the parking lot, that when he arrived, he said that he had a gun, that people charged him or lunged at him. We presented that to the grand jury. So all of that stuff was presented to the grand jury. So the question is, does this statement from Shay McConnell, does that change anything? Would that deter the grand jury from finding probable cause? And the answer is clearly no. It's not clearly exculpatory evidence, but I get what the judge is saying. Of course, and that's why you need to look at the whole picture. And the state did present all of those, the background, the foreground. We presented all of that to give the grand jury a picture of what happened. Chase Irwin's statements, the defense claims, is also clearly exculpatory. First of all, they did grossly misstate the evidence. Chase Irwin never said that the defendant that Colin Breaux ran at the defendant. And that's what they put. I'm almost surprised the defense didn't just stop talking about this, because they said that in their motion. I'm looking on page 12, top of the page. Irwin's observation of Breaux running towards Stephen, that's not a fact, that's not evidence, that's not what Chase Irwin said. So yeah, they did grossly misstate the evidence. So that's not misleading, that's misrepresenting the evidence, but it's also does not fall under the category of clearly exculpatory evidence. That Colin, an unarmed individual, ran across the street does not then give the defendant a right to shoot him dead. That's a ridiculous argument. The BAC of the victims, blood alcohol concentration, I'm not aware, we have Sergeant O'Hagan here, maybe we could ask him if he knew about the BAC. I'm not aware that anyone knew what the BAC of these victims were at the time of the grand jury presentation. Obviously, we're not required to introduce evidence we don't know about. But regardless, let's just suppose that we knew what the BAC of these victims were. Does the law say that if someone's intoxicated, you get to shoot them? Does the law even say that if someone's aggressive, you get to shoot them? No. How is that clearly exculpatory? Again, we didn't hear the defense explain how that is clearly exculpatory evidence. Detective Jacob Ellis was at the hospital, but he wasn't there taking the victim's blood. He wasn't there noting a lot of symptoms of intoxication. He was there to get some statements to find out what had happened. And these victims, we could hear on the recording that the judge heard earlier. Nick Peering, he's in the hospital. Nick Prado, he's in the hospital. Kyle Zentik's in the hospital. You can hear the beeping behind them. They're being treated for gunshot wounds. It wasn't the time to figure out what their BACs were. It's not a DUI case. Let's talk about the other category that the defense points to that they say is inaccurate or incomplete information. And again, it's not enough just to be inaccurate or a little misleading. It's got to be material to the indictment. So talking about that, in Peering's statement, we heard a little snippet, a little section of Peering's statement that he made at the hospital. There's a whole other interview that took place a few days later that the court has, that we submitted as part of our response, where he gives a more comprehensive interview. He talks about what had happened in more detail, The state did not mislead the grand jury about this. If you look at the grand jury transcript, it doesn't differ that much from even his first statement, but it certainly follows and parallels Peering's second statement, where he gave a more detailed account, gave a longer account about what happened. The recorded statement bears that out. And again, it's not material to the indictment. Whether or not Peering actually lunged at the defendant as well, and by the way, the state does not concede that any of his statements indicate he did that. He was running towards calling his friend to intercede when the defendant shot him twice. Even supposing, let's just argue for argument's sake, Peering ran at the defendant, he was unarmed. The defendant just shot another person twice. Does the defendant just get to shoot anybody who walks towards him? At that point, the only people in that area who were allowed to use self-defense were the people around the defendant. So the people that jumped on the defendant, they were acting in self-defense at that point. They were afraid for their lives at that point. And that's the reasonable person standard there. The defendant was the only person who had a weapon at that time. Let me talk about the trajectory of the bullets. The state, I'm kind of surprised we're arguing about this, but the state does not have an expert report from Dr. Zarnicki or anyone else opining about the trajectory of the bullets and what that means. We're not in a position, the state cannot be placed in a position where we are telling the grand jury, this is what this means. What we heard from Sergeant O'Hagan at the grand jury presentation was that they were at a downward angle or a down angle, I think is how he said it. We can argue about semantics, but how is the fact that there's a downward angle, that the trajectory of the bullets on Colin's body were at a downward angle, how does that change the calculation? How does that make it seem like the defendant is now acting in self-defense? Again, does that deter a grand jury from finding probable cause? No. Colin had no weapons. Even if he were lunging at the defendant, which by the way is disputed by a lot of the independent witnesses, he does not have a right to then shoot him dead. So the trajectory of the bullets, again, does not meet any standard that I could find in the law. The defense has failed to adequately explain that as well. The defense just, I guess they're not addressing the defendant's self-serving statements he made in the patrol car. I think our response, we can just rest on that issue. The defense injuries, these were not materially misleading. The statement that I believe Sergeant O'Hagan made to the grand jury was that he was punched in the face. There may have been an indication that he had a split lip, that he lost his balance at one point. The injuries were superficial. All the injuries that the defense pointed out in a police report, I noticed that they didn't include any photographs of the defendant's injuries because they are just little scrapes and bruises, nothing more. So we don't know where they came from, what or when they happened. It's possible he received a bloody lip when he was initially punched in the face. But either way, it's not clearly exculpatory information. The defendant is only allowed to use physical force, not deadly physical force. So the fact that he got some scrapes and bruises did not indicate that he was in that position where he needed to use deadly physical force. His injuries don't add anything to that analysis. So basically, Judge, what the defense is arguing is that the state didn't present the defense's entire case to the grand jury. And that's not the purpose of the grand jury proceeding. And let me, by way of an example, talk about some of the case law to understand what type of information the state is supposed to present. In State v. Harrell, which was cited by the defense, although they cited just for a generic purpose, in that case the defendant had chased down a car that he thought contained his daughter. He was looking for his daughter, he thought she was in trouble, and so he was chasing this car down. He had a little BB gun with him. He ended up going around the neighborhood, following this car, had a confrontation with people in this car. It turned out it was the wrong car. Okay? And the people in that car was just a family not related to this incident. They called the police. He was arrested. The grand jury, at the presentation of the grand jury, they were read the crime prevention statute, but the state failed to present information, any background information, that he was looking for his daughter, that he thought she was in harm's way. And so that, the court decided, was enough to send it back to the grand jury. That's completely distinguishable from this case. Here we read all the applicable justification statutes. You have the grand jury transcripts. I know you've read it. We read all the self-defense statutes, crime prevention statutes, spent time explaining what those meant, read the definitions, and then we included all these events in a grand jury presentation. Let me just go through them. Information that while the defendant was in the street, he got punched in the face, that his glasses got knocked off. Information that Shane McConnell and Jacob Mike, who were the defendant's friends, were pushed to the ground initially, and that McConnell was also punched. Information that the defendant thought people were chasing him, which turned out not to be true, but we presented that anyway. That he thought he was going to die, that he needed to defend himself, that was presented. That later one of the Delta Chi members lunged at the defendant when he had the gun. That two guys rushed toward the defendant. That afterwards several people piled on the defendant. That the defendant yelled out to call the police. That Jacob Mike actually called the police and said his friend was being assaulted. This is all included. That there were statements from the defendant that he didn't want to do this, that he didn't want to hurt anyone, or that Colin and Peering were angry about guys who crashed the party earlier. Information that the defendant tried to help one of the guys or to render aid. Information that according to the defendant, people were saying they were going to kill him, although that's disputed by everyone else. Also that he warned the people around him that he had a gun, and that when he displayed the gun, he thought they were going to kill him. We presented essentially this self-defense argument for the defendant. This is a fair and impartial presentation to a grand jury. I would agree with the defense, had we left all that out, just read the statute, for instance, like in Harrell, just read the statute of self-defense and just didn't include any of that information, we'd have a problem. But we didn't. We included all of this information, included all the justification statutes. How can the defense now say we didn't present a fair picture? We presented their entire case. Now, the grand jury rejected that self-defense claim. We don't know exactly why they did that, but perhaps it was because the defendant went to his car, made a decision to get his Glock 40, and then walked 90 feet toward the spray and start shooting unarmed people. We don't know exactly what the grand jury was thinking, but clearly they rejected this self-defense claim. Judge, as the court is aware, the state is only required to present a fair and impartial picture. We're not required to present the defense's case or argument. Again, I agree with the defense. This is not the time to try the case. This shouldn't devolve into a mini trial. And credibility, as I quoted from Trevis, credibility or consistency of statements is not the issue at this stage. Neither is the sufficiency of the evidence. The state made a fair and impartial presentation to the grand jury. We're asking the court now to deny the defense motion. Thank you.
Thank you, Mr. Parker. Mr. Davidson, brief reply.
Yes, Your Honor. These aspects of the case and the evidence that the prosecutor lists off that were ostensibly favorable to Mr. Jones and were offered to the court to ostensibly leave it with the impression that they did come into the grand jury and give them a fair and impartial presentation, completely ignores the fact that when they did provide information about what Stephen said, they disparaged it and they presented it as self-serving statements, much like he has this afternoon. It's astonishing to me, Your Honor, that we have a case where the discovery is so voluminous, it takes up 3 notebooks like this. We have a group of drunk undergraduate college men chasing my client and his friend through a parking lot. There's no dispute, excuse my language, that they're calling him pussy, that they're calling him faggot. No one else may have actually heard the word kill, but to represent to the court that no one else heard somebody making threats against Stephen other than Stephen simply isn't so. So they present the evidence. They say, well, yes, Stephen might have said that, but we all know it's true because all these other people, all of the decedent's likely impaired friends didn't corroborate it, that somehow we should ignore it, and that the state was entitled to downplay it during the grand jury presentation. Well, A, that's just not so. B, I don't think that anybody, myself or the prosecutor, could stand before you with such great certainty of what happened and what didn't happen when you have dozens of witnesses who have been interviewed and provided conflicting accounts about some of the minor details of this case. What we do know, Your Honor, is that Mr. Jones made it abundantly clear that he fired that gun because he was acting in self-defense and he thought these 2 guys were lunging at him. Yes, they conveyed that statement to the police, to the grand jury. But they made it sound like he was making it up. They made it sound like it was just a self-serving statement he was saying to get out of trouble. And it makes it very easy for them to do that when they leave out all this corroboration. When they leave out the fact that Peering says that he was basically right behind Colin, jumping from an elevated position, mind you, towards Mr. Jones at the very moment when Jones says, step back. Now, the fact that Mr. Peering's subjective intent at that point may have been to assist Colin Bro or do something other than attack Stephen is irrelevant, and it's a distraction from the issue before the court, as is all this talk about Glock pistols at 90 feet of distance. The reality of it is that statement from Peering himself corroborates what what Mr. Jones says happened. And it's not just that they left it out, Your Honor. I would invite the court to look directly at page 56 of the transcript. They told the grand jury that that's what Mr. Peering said at the hospital. Now, the story today is, well, there was a heart monitor beeping in the background. We couldn't possibly give any credence to what Mr. Peering said under those conditions. Well, obviously, they thought a hospital setting right after the incident was a very reliable scenario in which to obtain a statement from somebody, A, because they took the statement. They took 2 statements during that period of time. And B, when they presented to the grand jury, when they presented Mr. Peering's subsequent statement to the grand jury, the one that fit the narrative, they misrepresented it. They said he said that at the hospital. It's right there in black and white. Now, Nicholas Peering was at that scene too. Is that right? Answer, yes, he was. Question, and was he spoken to? Answer, he was. Question, was he spoken to at the scene or later at the hospital? Answer, later at the hospital. Well, he was spoken to at the hospital. They just didn't like the information that he gave at that point, so they substituted in what he said a week and a half later. And that statement from the hospital, had they presented it, would have corroborated what Stephen said. It's very easy for the state to stand here and have the court look just at Mr. Peering's statement, just at Mr. Zintek's statement, just at Stephen's injuries and say, you know, Judge, that by itself doesn't entitle Mr. Jones to grab his gun from his car, walk across a parking lot 90 or 100 feet and start shooting people as if that's what happened. Well, of course it doesn't, and it's not the defendant's position that that happened. But as the court correctly noted, it's the totality of the circumstances here. It's not the appropriate analysis to look at each of these by themselves and say whether each individual omission or misstatement by the state on its own would have been a basis for the jury to find that Stephen acted with reasonableness or that he didn't act with premeditation, an issue that I didn't hear the state discuss just now. Certainly when you view these things collectively, and certainly when you view these things against the backdrop of the larger fray in which this all happened, yes, it was clearly exculpatory that Peering said he was jumping in the defendant's direction when the shots were fired, and at a moment, obviously, when Stephen was fearing for his life, because the words that he was uttering at that point were to step back. Obviously, it's clearly exculpatory, particularly when they continue to dispute to this day that Colin Breaux was leaning or lunging towards the defendant, that the medical report all but corroborates that fact, and they left it out. What exhibit number is that document? Yes. No, I'm sorry, the document. May I approach, Your Honor?
Sure.
Okay. This is Defense Exhibit 1, Your Honor. This is a search warrant that was authored by the police prior to the presentation of the case to the grand jury. Signed like all search warrant affidavits are under oath. By Detective Converonet. I would invite the court's attention to the third paragraph on what's date stamped 77. An autopsy was performed on Colin where it was determined that he was shot once in the chest and in the shoulder. The trajectory of the shoulder injury suggested that the round was incurred by the victim as he was leaning or falling forward. So here we are today. The state takes position that without medical expert testimony that we can't draw any inferences from the trajectory of the bullet. But when they presented the case to a magistrate to get a search warrant, the police obviously had no problem making that inference. And of course they made that inference because any reasonable person could make that inference. So it's a non-starter that the medical examiner's findings were not relevant and didn't draw or didn't allow the grand jury to draw any conclusions.
Mr. Davidson,
yes?
Which shot occurred first? The one to the chest or the one to Mr. Breaux's shoulder?
I don't know.
Well, your position is that Mr. Breaux was lunging forward.
Both bullets were described in the medical report as having a downward path. May I have a moment?
Sure.
Referring to date stamps 445 and 446.
What exhibit?
Well, it's not before your court. I could have this marked if you'd like. This is Dr. Sarnecki's report. He describes the gunshot wound to the chest. The trajectory was the wound track reveals from the decedent's front to back, right to left, and downward. He then separately describes the gunshot wound to the shoulder. Trajectory. The wound track travels from the decedent's front to back, right to left, and downward. Both shots are described by the medical examiners having a downward track. So the sequence of the shots, I would respectfully submit, are not relevant with respect to that particular issue. If it were an undisputed issue as to whether Colin Breaux was lunging or leaning towards the defendant, maybe it wouldn't be a big deal. If it was an undisputed issue as to whether or not Colin Breaux's physical demeanor towards Mr. Jones was something that he considered in perceiving the threat that he was facing was not important, it wouldn't be that big of a deal. But neither of those things are true. This is perhaps one of the most The state cites a passage from my motion concerning Mr. Irwin's statement at the very end, where I write, because the reasonableness of Stephen's perception that Breaux represented a threat to his life was essentially the central issue determined by the grand jury, Irwin's observation of Breaux running towards Stephen was clearly exculpatory and should have been presented. Well, yeah, if that's all I wrote, I suppose I have to own up to that. But what he conveniently left out was the sentence for the paragraph right before that, where I made it very clear that Irwin told Detective Rodriguez that right before the shooting, he witnessed Breaux running across the street toward the parking lot, parentheses, where Stephen was located. It's pretty clear in the motion what Mr. Irwin said. It's pretty clear in the motion the fact that he was running towards Stephen was a reasonable inference. And I think it's likewise pretty clear that they knew the grand jury was going to make that inference, which is why they didn't present it to him in the first place. All that being said, Your Honor, the bottom line here is that as much as the state wants to make their closing argument today and try the case and make it seem like it's such an open and shut case that we shouldn't even be squabbling over these things, that's not what we're here for today. The issue is whether Mr. Jones's case was presented fairly and accurately to the grand jury. I have laid out for the court numerous issues and numerous factual portions of this investigation that clearly would cut in favor of Mr. Jones's reasonable use of self-defense and also absence of premeditation. We heard a lot about these 90 feet. We heard a lot about the fact that he went to his car and then went in a different direction before the shooting occurred, as if Mr. Jones just started firing shots as soon as he grabbed his gun and came from the car. What the state leaves out is the fact that whether Stephen had walked 90 feet or 900 feet from his car when he approached Breaux, with Peering right beside him, and they're squaring off and they're lunging at him, he wasn't pointing his gun at him at that point. He certainly wasn't shooting at that point. He was holding his gun towards the ground in what was described as a low ready position. And it wasn't until they lunged at him and made a furtive movement that he fired, and he fired in self-defense. Now, the fact that Peering said that he was jumping at him at that time, the fact that Breaux's Breaux's injuries were such that it corroborates what Stephen says, that Breaux was seen running in the general direction where this all occurred and where Stephen was located, that Zintek said, in his words, that Breaux got up in Stephen's face, pretty close were the words that he used. That's all clearly exculpatory in the context of this case. And it's not just clearly exculpatory as to the issue of self-defense, Your Honor, but it's also clearly exculpatory as to the issue of premeditation. The state has taken the astonishing position in this case that Mr. Jones killed Colin Rowe with premeditation. That obviously requires reflection and thought and pondering on behalf of the defendant. Now, how could a grand jury possibly make an informed decision about whether a defendant acted with premeditation if they're not told about all the evidence that shows that the alleged victims were basically jumping or lunging at him at the very moment in time that he fired his gun? And that's exactly what happened here. Now, if they want to discredit this evidence, if they want to explain it away, if they want to take the position that we don't have to say that Ziering said that, or excuse me, that Zintek said that Breaux got in Stephen's face because he later said it was 4 feet away, then what they should have done is told the grand jury that, well, Mr. Zintek said that he saw Breaux getting in Jones' face, but then later, on further questions, said it was 4 feet. That's what they should have done. Present the statement. Don't just, it's not within the state's purview to make their own independent determination as to whether or not there's sufficient evidence out there to discredit an exculpatory statement. When Zintek says in no uncertain terms that he saw the decedent get, in his words, pretty close and in the defendant's face right before the shots were fired, in the context of this case, Judge, that's clearly exculpatory. And if they want to hide behind the fact that he later quantified the distance at 4 feet upon further questioning, they can do that, but they should have just at least presented the whole statement to the grand jury and let them make their own determination, not substitute their judgment for that of the grand jury, because that defeats the whole purpose of it, and that's exactly what happened here. That's why this case needs to go back.
Thank you, Mr. Davidson. The court has reviewed the pleadings as well as the entire grand jury transcript in this case. The court at this time will deny the motion to remand to grand jury for a new determination of probable cause. We've been at this for about an hour and 20 minutes. We'll take a break. So let's just stand at recess for about 5 minutes, okay?